Hi, everybody. Welcome back. Recall the task that we set for ourselves in describing the systems of tort and criminal liability, an objective borrowed from Professor Williamson. That is, we're trying to match transactions that differ in their attributes with governance structures that differ in their capabilities in such a way as to minimize the transactions costs and thus, by minimizing those costs, to facilitate transactions in all kinds of environments. So, on that basis, let's talk a little bit about the transaction that takes place when a crime is committed and compare it to the transaction that takes place when a tort is committed. As in tort, the law creates an entitlement in every individual, summarized typically as the people, an entitlement to be free of the moral costs of certain acts deemed crimes. This is the first step in actually organizing the transaction. It is, as we suggested in the Kosian discussion that we had earlier, the first thing that the state must do, which is to initially place property rights before any kind of exchange can take place. In the criminal case, this initial entitlement setting deems certain acts that impose moral costs to be crimes. And as in tort, the transaction occurs when the offender seizes and extinguishes all of these entitlements on the part of these individuals to be free from the moral costs of crime. And he does this by committing the crime and thus by imposing the moral costs. So this is the first half of the transaction as we described it, an involuntary seizure of the entitlements, that is without the consent of the entitlement owners by the offender in the act that is deemed to be the crime. So when the offender commits the crime, he seizes these entitlements that have been placed by the law in the cost bearers, that is in the people of the society generally. As in the steel plant example, and differently from individual tort suits, the moral costs of crime are individualized. That is, they're different from individual to individual, and they're spread over many different cost bearers. And this, as we've seen in the case of the steel plant, makes class action an effective way to organize the completion of this many-sided multilateral transaction. Because, as I've said, the moral costs of crime are individualized, there is no competition in moral costs, as it were, that will drive the price of particular entitlements down to an easily observable value. And of course, because these are spread over many cost bearers, if there were no class action analog in the criminal system, then of course there'd have to be many, many different individual liability suits, criminal liability suits, in theory by the bearers of cost one at a time against the offender. And of course, this would be extraordinarily difficult and extraordinarily uneconomic. So, as we've suggested, in criminal cases, the state takes the role of our attorney entrepreneur in the tortious class action situation. The state acts as an agent, that is, acts in the name of the many cost bearers whom the legislature has given that initial criminal entitlement to. But there are differences between the steel plant situation and the criminal liability situation. One difference is that in the steel plant example, as we've seen, the costs are all economic, and thus they have, as it were, more or less accurate representations in the market prices of the particular goods or the particular things that have suffered damages at the hands of the cost imposer. Insofar as good health is a good, as it were, an entitlement that can be valued more or less accurately according to the rules of tort, then those costs too are objective. And when they're objective, market prices provide a useful guide for juries in determining tort liability because those economic prices, the prices of goods, represent the value, the economic value of what people have lost in tort. But in the case of crime, the costs imposed by crimes are not economic, they're moral, and they're not objective, they're subjective. This is because, as I've said, there are no markets in the moral effects of crimes, and therefore there's no way really to have these effects priced easily. There are no market prices that provide a reasonable or plausible analog or estimation for given moral costs. They have to be determined by introspection. If I'm to determine what the moral costs that you've suffered are, then the only way that I could do so is by asking you, or alternatively to try to put myself in your shoes and try to determine how I would feel if I were in the situation of having to bear the moral costs that you have to bear. So one difference between the costs of torts and the costs of crimes is that the economic costs of torts are objective and relatively easily measured by market values, whereas the costs of crimes are moral and they're subjective. They don't have easily available objective counterparts, and thus the moral costs of crime are very difficult to reduce to monetary values that might be the basis of criminal liability. A second difference between the costs of torts and the costs of crimes is that to a far greater extent than the economic costs of torts, the moral costs of crime differ from case to case. Moral costs are radically individualized. They depend extremely closely on all of the circumstances of the case. It matters who the victim is. It matters what kind of person the victim is. It matters who the perpetrator is and what kind of person the perpetrator is. And it matters the circumstances that the crime was committed in. Was there an excuse? Was there a justification? Was there a provocation? Was this an especially heinous offense because of some characteristic of the offender or the victim? And so on and so forth. So the moral costs of any crime, any abstractly defined crime, will vary greatly from case to case because the moral costs that are imposed by each crime are so closely dependent on the circumstances of the case and the identities of all of the parties to the transaction itself. And so, compared to the entitlements in free exchange and to the entitlements in tort liability, criminal entitlements are strongly non-homogeneous, and as a result of their non-homogeneity and their subjectivity, the subjectivity of moral costs, criminal entitlements are very difficult to price in the liability system. It's very difficult to determine what the appropriate price to be brought back to any offender will be, the price that perfectly or close to perfectly internalizes the moral costs that were generated by that offender's offense. Excuse me. As one justice put it, Justice John Harlan II, in a famous case, indeed a case that we'll be talking about ourselves soon, Harlan said, "Given the infinite variety of cases, and the facets to each case, an attempt to determine before the fact what criminal liability prices ought to be would be a failure in Harlan's eyes. If we were to try to offer potential offenders in the law itself some clearer idea of what the moral costs of their particular offense might be, and thus what the punishment price or liability price that will be inflicted back upon them might be, Justice Harlan believes that the infinite variety of cases, the infinite individualization of the moral costs that are imposed by particular crimes, would render the exercise of trying to price crimes before the fact extremely difficult and would lead, in Harlan's words, to meaningless boilerplate. That is, platitudes or statements that were so broad and so vague that they were meaningless and unable to be applied to the facts of particular cases." Let me give an example of the individualization of moral costs that was suggested by the attempt of the state of Massachusetts, just north of Connecticut, where I am now. The state of Massachusetts several years ago attempted to impose a mandatory sentencing law on the illegal possession of concealed handguns. I recall there was a sign on the highway as one entered the state of Massachusetts, driving from the state of Connecticut, that warned drivers that they were entering Massachusetts, where there was a mandatory 1-year term for any illegal concealment of a handgun, an illegal concealment of a firearm. So let's imagine that you're the judge in Massachusetts and you're being asked to enforce this mandatory 1-year term for illegal concealment of a handgun. And one morning you happen to be faced with two cases, one right after the other, that both have charges relating to this mandatory sentence. That is, we have two different defendants, each of whom has been arrested for violating this law, that is, for illegally carrying a handgun. One of these defendants, we'll assume, is a cold-blooded contract killer, perhaps an organized crime figure who makes a living by killing other people, and this just happens to be all in a day's work for him. He was arrested, we'll assume, as he was going to his latest contract killing, and he had a concealed weapon, and so he's brought before the judge, and the judge is asked to pass sentence for this particular crime. The judge might have very little difficulty sentencing this particular defendant to the mandatory 1-year term. This is obviously a bad guy. This is the sort of person that mandatory sentences are meant to deter, and so indeed it might be perfectly appropriate to inflict a mandatory 1-year term on this particular individual. Indeed, it might be appropriate to inflict a larger term than that for this particular crime, since it's liable to make people rather angry given the nature of this particular defendant and what he does for a living. Now compare that hitman to a second defendant, a 16-year-old boy, let's say, who's been bullied at his urban high school for months and months. He's now extremely anxious about going to school. He's fearful of the kids who are going to bully him and who keep threatening to beat him up. And so, perhaps foolishly, he decides one day to bring a gun to school in hopes of fending off or deterring the bullies from attacking him, as is their habit. Unfortunately for him, before the bullies strike and before he can wield the handgun to frighten them away, he's stopped by a policeman who discovers his illegally concealed handgun, and he's brought as the second case before our judge. And now the judge faces the same mandatory 1-year term to be imposed upon this individual. But sending that teenager to jail for a year is likely to cause enormous damage to that young man. He's liable to be treated badly in the prison, much worse in the prison than he was at the school, and he's liable to come out of that 1-year term in prison much more likely to lead a life of crime than if he'd never been sent to prison in the first place. But if there's a mandatory 1-year sentence associated with his crime, then the 1-year sentence must be imposed. This is why mandatory sentencing laws are so problematic, because in fact they conflate all sorts of crimes down to a single crime, as it were, and assign a single penalty to that conflated crime, even though by assigning that single penalty, the problem arises, or the danger arises, that many, many individual cases will be resolved with erroneous liability prices because the mandatory term has prevented the sentencing authority, the judge or the jury, from considering all the circumstances of the case, considering the identities of the offender and of the victims, and then fixing a sentence which they believe appropriately measures the actual moral costs imposed by this crime. So, how are criminal entitlements priced in the United States? The answer is that they're priced in a two-stage pricing process that involves both legislatures, the original determiners of criminal entitlements and the range of criminal sentences, and trial courts themselves, which, after the crime has been committed, on the basis of the evidence placed before the judge and the jury about the circumstances of the case and the identity and situations of the offender, the trial court And the sentencing authority in the trial court, whether that's the jury or the judge, then fixes the final penalty for a crime within the range of sentences which have been set by the legislatures for crimes in the abstract. What do I mean by a crime in the abstract? Consider armed robbery, which can easily be defined in the abstract. Robbery is the taking of another person's property by force, and armed robbery is a robbery using a weapon. So it's relatively simple to describe armed robbery in the abstract, and this is how most statutes, indeed all statutes that define crimes like armed robbery, are written. They have words like, a person who commits a robbery with a weapon is guilty of an armed robbery. Or, a person who takes the property of another by force using a weapon is guilty of an armed robbery. I call this a crime defined in the abstract because, in fact, it says nothing about who the offender is, it says nothing in particular about the victim, and it says nothing about the circumstances of the crime. It defines the elements of the crime in the barest, sparest, most abstract way possible, so that very, very large numbers of different kinds of acts could, in principle, be collected under the rubric of an armed robbery, some of them raising very serious moral costs, and some of them creating less serious moral costs. So, legislatures define crimes in the abstract, like the crime of armed robbery, and when they do so, they allocate the criminal entitlements corresponding to those crimes to the people who would bear the moral costs of those crimes. Then the legislature ranks these abstract crimes by their degree of seriousness. As we've suggested earlier, murder is a more serious crime than armed robbery. Armed robbery is a more serious crime than robbery. Robbery is a more serious crime than larceny. What this means in our interpretation of criminal liability is that murders typically impose more moral costs than armed robberies. Armed robberies typically impose more moral costs than robberies, and robberies typically impose more moral costs than larcenies. Once abstract crimes have been ranked by the legislature in terms of their seriousness, the legislature then fixes a range of liability prices for abstract crimes, and then the actual price, which will be imposed upon any given convicted criminal, will be determined after the fact of the crime from within that range of penalties specified by the legislature. The actual penalty will be determined after the fact by the jury as it measures the moral costs of the crime in terms of the circumstances of the case as they've been revealed in the criminal proceeding itself. So let me give you some examples that are taken from the Connecticut Penal Code, which was produced in the building on the slide. That's the state capitol of the state of Connecticut, where the Connecticut General Assembly meets. Thus, for example, here are 4 crimes in the Connecticut Penal Code: bribery of a public official, first-degree strangulation, you can imagine what that means, second-degree burglary, and third-degree arson are all characterized by the Connecticut legislature as what they call Class C felonies, and all Class C felonies are punishable by imprisonment between 1 year and 10 years. Thus, if I've committed a second-degree burglary, for example, then I'm liable to a penalty between 1 and 10 years in prison. What that penalty will be is determined only after I've committed my second-degree burglary and the case has been laid in full before a jury or a judge, and then the jury or judge selects a penalty somewhere between 1 and 10 years of imprisonment, which they believe best captures the moral costs that were imposed by my particular second-degree burglary, which is in principle different from anybody else's second-degree burglary under different circumstances. Similarly, here are 3 more offenses: trafficking in persons, which generally means the commercial exchange of human beings for illegal purposes; First-degree manslaughter and second-degree kidnapping are all classified by the Connecticut legislature as Class B felonies and subject to an imprisonment term somewhere between 1 and 20 years. These are more serious crimes, and therefore the penalties that the legislature authorizes for them include a much larger range, all the way up to 20 years. And finally, we get to the Class A felonies, crimes such as first-degree kidnapping, first-degree arson, and first-degree sexual assault, all of which are Class A felonies subject to imprisonment between 10 and 25 years. And once again, once the crime is committed and the circumstances are laid before the sentencing authority, then moral costs can be measured more accurately and some term between 10 and 25 years selected as the liability price for any given person who's been convicted of a Class A felony. Then, after these crimes have been defined and the range of punishments fixed by the legislature, crimes are actually committed. And when crimes are committed, the abstract definitions become real stories. That is, crimes are not committed in the abstract, they're committed by a specific perpetrator, and they're committed on a specific direct victim, in a specific universe of factual circumstances, creating a case-specific array of moral cost. That is, because of all of these major differences in the circumstances of the case, who the perpetrator is and what his or her situation is, who the direct victim is and what his or her situation is, the larger story that surrounds the criminal transaction, that is, the universe of factual circumstances within which the crime is committed, all of these combine to produce different levels of moral cost for different crimes, even crimes of the same abstract definition. And these costs can only be estimated after the crime has been committed, once all the facts that determine what the moral costs in this case actually are have in fact been created. After all, the facts that determine the moral costs are created by the offense itself, and therefore it's not possible to accurately measure them until the offense has actually been created. So the final liability price to be inflicted upon criminal offenders requires information about the specific circumstances of the crime so that the moral costs of this crime can be estimated, and our system leaves the task of this final liability price determination typically to a criminal jury. Here's a picture of one, a rather ironic one produced in the 19th century. Juries are meant to be representative of the society. As the Supreme Court has said, in criminal cases, it's the job of the jury to represent the community and its evolving standards of what constitutes a serious or a less serious crime. The jury stands in as representatives of the entire class of moral cost bearers, and they do their best on the basis of the information that's presented to them during the criminal proceeding, on the basis of the evidence at the trial and the arguments made on both sides of the trial. The jury determines first whether the defendant has in fact taken the entitlement, that is, whether he's guilty or innocent, and then determines what the liability price will be as it tries to estimate the moral costs, standing in for all of the moral cost bearers themselves. All of this two-stage pricing creates a very serious problem for the criminal justice system, which I call the information paradox. Recall our discussion of competitive exchange and the way in which the price of oranges was driven down to the marginal cost of producing them, so that the price that a prospective consumer faces for the consumption of any given orange represents the sum of all of the costs that have had to be borne by all of the individuals who have contributed resources or property to the production of that orange and the making it available to the consumer. So, competitive prices, we said, simultaneously look backward by measuring precisely the costs of producing the good which is being proposed for exchange, and those competitive prices at the same time look forward by informing prospective consumers exactly what they will have to pay in order to have the good. When the consumer walks into the store and looks at that $1 price tag for the orange, she knows how much the orange has cost other people to produce, and she knows how much she will have to pay in order to consume it herself. But in the case of liability, as we've seen, the involuntary taking or seizure of the entitlements means that the exchange between the cost imposer and the cost bearer is broken in time. The cost imposer, by committing the tort or the crime, inflicts costs upon a large class, in the case of crime, on a large class of cost bearers. But that cost is not internalized through the infliction of a liability price until some time later in time. That is, the transaction does not take place instantaneously with the exchange of goods. The first half of the transaction, the cost imposition, takes place well before the second half of the transaction, the exaction of the liability price. Both tort and crime are subject to this breaking of the exchange in time. But in tort, the economic nature of the costs and the market prices, which are good estimators of those economic costs, allow relatively predictable measurement of costs at a trial. And because these costs are relatively predictable, they're not just relatively easy for tort juries to determine, they're also relatively easy for prospective cost imposers, people who might commit torts in the future, to know what they too will have to pay as a liability price in order to seize similar entitlements. But in crime, the two-stage pricing procedure faces a very serious dilemma, even when it works well in ultimately setting liability prices that accurately measure the moral costs that are imposed by any given crime. In order to measure the moral costs actually imposed by any specific crime, as we've seen, the crime must actually have taken place, so that all those facts and circumstances that determine what the moral costs of this crime have themselves been created. So, to measure moral costs, we need to look backwards, as my left-hand Janus is looking in this particular picture. But if liability prices are not determined until after the crime takes place, then prospective offenders, those who haven't yet committed their crimes, but are thinking about committing crimes and would need to know what the price of their crimes might be, these prospective offenders have no way to know with precision what the price of their crimes will be, and thus they have no way to distinguish efficient crimes from inefficient crimes before those crimes are committed. So the information paradox is that the two-stage pricing process, by looking backward in determining punishment prices or liability prices after the fact, make it very difficult for those prices to inform potential offenders in the future, and as a result, they make it very difficult for potential offenders to distinguish efficient from inefficient offenses.